Robertson.
In conclusion, Mr Chair, can I endorse what other members have generously said and thank the officials, particularly the clerk and Deborah Angus for their wonderful work, and Ross Carter. As Mr Robertson said, it may look as though there's been a complete redraft because we were dissatisfied with the earlier version, far from it, but we wanted to make this very important area of the law as clear as possible. Can I simply say that the committee stages of the debate have really emphasised the importance of what is now Clause 8b, and particularly subclauses 4 and 5, for the avoidance of doubt in determining whether the words spoken or acts done for the purposes of or incidental to the transacting of the business of this House or of a committee. No necessity test is required or permitted, and subclause 5, very importantly, spells out what that is, and it's very, very important that all those who read this legislation understand that fundamental point, that there is no necessity test which can read down what members of Parliament say or do. The final point I'd make, and it's picking up on something Dr Graham said about our constitutional legislation, and this is important constitutional legislation and no one should be under any illusion as to that, is that today we are going to finally remove the last vestiges of the Legislature Act 1908. And anyone listening to this debate may say, well, gee, that's a big change to repeal the Legislature Act 1908. But the reality of the matter is that all but Section 242 of the Legislature Act was repealed years ago. So we're removing the last remaining section of the Legislature Act, but it does give rise to a more general principle, and that is whether the time has come at some stage for Parliament to look at consolidating all the legislation relating to Parliament in one coherent piece of legislation. And I see Dr Graham nodding, and I think that that could be quite an interesting bipartisan or multi-partisan project in the next Parliament, because it is in the public interest that all provisions relating to our constitutional arrangements are there and clear and easily accessible for people, and you shouldn't have to go darting and diving for Section 242 of the Legislature Act. Under the Legislation Act, the Attorney-General has the power to set forward a program for revision of statutes, and I've sent to my opposite number, Mr Parker, a proposed revision program, regardless of who may be here after the election. But I think it could be a worthwhile project to bring all the legislation together, just as Mrs Collins has done with the courts legislation, the courts modernisation legislation. The Judicature Act 1908 was hopelessly out of date. Most of that had been repealed. So what she has done, and it's a very good piece of work, has brought together all the relevant court legislation into what will become known as the Senior Courts Act, and then there'll be the District Courts Act. So I think that it's in the public interest that there be a consolidation of all the parliamentary legislation, and that could be something that all parties could work sensibly on, because, as Dr Graham says, it is in the public interest that all our constitutional legislation be readily accessible and available, set out in clear terms for the benefit of the public. So this has been a very interesting debate. I echo what Mr Hipkins said. We looked at this word privilege because when at first sight it looks as though we're on the final day of the 50th Parliament ramming through legislation and urgency to protect ourselves. Well, actually, let us be clear about one thing. When we talk about parliamentary privilege, it is not the privilege of individual members of Parliament, it's the privilege of Parliament. And it's the collective privilege, and it is there for very clear purposes, and they have been very eloquently set out by Mr Hipkins in his previous contribution. I don't need to repeat them. But when one looks at legal professional privilege or parliamentary privilege, it does have connotations of lawyers looking after themselves and parliamentarians looking after themselves. Get beyond the terminology, drill down to what we've been trying to do in this debate, and that is ensuring that in the public interest, Mr Chairman, important issues can be transacted in this chamber, and that the important rights of parliamentarians to raise important matters is not curtailed or circumscribed in any way. And so, putting it bluntly, it was the unanimous view of the Privileges Committee, and I take it from of this Parliament, that in two very important cases the courts got it wrong, and that is why, with the greatest of respect, Parliament has needed to put it right.
Members, we come to the vote on parts 1 to 2 and clauses 1 and 2. First, we have the Minister's amendments as set out on SOP number 482. The question is that the amendments be agreed to. Those of that opinion will say aye. To the contrary, no. The ayes have it. The question now is that parts 1 to 2 and clauses 1 and 2 as amended stand part. Those of that opinion will say aye. To the contrary, no. The ayes have it. I will report this bill with amendment.
The House is resumed, Mr Chairman.
Mr Speaker, the committee has considered the Parliamentary Privilege Bill and reports it with amendment. Mr Speaker, I move that the report be adopted.
The question is that the report be adopted. Those of that opinion will say aye. Against, no. The ayes have it. This bill is set down for third reading forthwith. Is there a minister? Yes.
Mr Speaker, I move that the Parliamentary Privilege Bill be now read a third time.
The question is that the motion be agreed to. Those of that opinion will say aye. Contrary, no. The